Good afternoon to one and all. I am Kaushiki Roy, Assistant Professor at IIMT College of Law, is here to discuss about the general defenses under law of torts. Now we will start with the meaning of general defense. What is general defense? When a plaintiff brings an action against the defendant for a tort committed by him, he will be held liable for it if there exists all the essential ingredients which are required for that wrong. But there are some defenses available to him using which he can absolve himself from the liability arising out of the wrong committed. There are these are known as general defenses in the law of tort. The defenses available are given as follows. There are basically 8 defenses under law of tort, which are here as follows. First one is voluntary non-fit injuria or the defense of consent. Second one is the plaintiff is the wrongdoer. Third one is the inevitable accident. Fourth is act of God. Fifth is private defense. Sixth is mistake. Seventh is necessity. And the eighth and the last one is statutory authority. Now we will discuss with the first general defense, that is the voluntary non-fit injuria. This is the most important general defense under law of tort. So voluntary non-fit injuria is in case a plaintiff voluntarily suffers some harm, he has no remedy for that under the law of tort and he is not allowed to complain about the same. The reason behind this defense is that no one can enforce a right that he has voluntarily abandoned or waived. Consent to suffer harm can be expressed or implied. Some examples of the defense are when you yourself call somebody to your house, you cannot sue your guests for trespass. Second example is if you have agreed to a surgical operation, then you cannot sue the surgeon for it. Third example is if you agree to the publication of something you were aware of, then you cannot sue him for defamation. There is a very famous case for this voluntary non-fit injuria is in Padmavati versus Dugganayaka. The driver, facts of the case is the driver of the jeep took the jeep to fill petrol in it. Two strangers took a lift in the jeep. The jeep got toppled due to some problem in the right wheel. The two strangers who took lift were thrown out of the jeep and they suffered some injuries leading to the death of one person. The conclusion which came out of this case are the master of the driver could not be made liable as it was a case of sheer accident and the strangers had voluntarily got into the vehicle. The principle of voluntary non-fit injuria was not applicable here. Next is involuntary non-fit injuria. There is one point also, that is the consent must be free. The consent must be free. For this defense to be available, it is important to show that the consent of the plaintiff was freely given. If the consent was obtained under any compulsion or by fraud, then it is not a good defense. The consent must be given for an act done by the defendant. For example, if you invite someone to your house for dinner and he enters your bedroom without permission, then he will be liable for trespass. For showing the consent, there is also one famous case, that is Lakshmi Rajan versus Malar Hospital. In this case, a 40-year-old married woman noticed a lump in her breast, but this pain does not affect her uterus. After the operation, she saw that her uterus has been removed without any justification. The hospital authorities were liable for this act because the patient's consent was taken for the operation, not for removing the uterus. If a person is not in a condition to give consent, then his her guardian's consent is sufficient. Now here, consent obtained by fraud. Consent obtained by fraud is not real consent and does not serve as a good defense. Here in case Hegarty versus Fine, it was held that mere concealment of facts is not considered to be a fraud so as to vitiate the consent. Here, the plaintiff's paramour has infected her with some vulnerable disease and she brought an action for assault against him. The action failed on the grounds that mere disclosure of facts does not amount to fraud based on the principle ex turpi causa non oritur actio. That means no action arises from an immoral cause. In some of the criminal cases, mere submission does not imply consent if the same has been taken by fraud, which includes mistake in victim's mind so as to the real nature of the act. Here is certain limitations on the doctrine of voluntary non-fit injuria. The scope of the maxim voluntary non-fit injuria has been curtailed in the following cases. First one is rescue cases, and second is the Unfair Contract Terms Act 1977. In these cases, even if the plaintiff has done something voluntarily, but he cannot be met with the defense of consent, that is voluntary non-fit injuria. Now, I will discuss about the rescue cases. When the plaintiff voluntarily comes to rescue someone from a danger created by the defendant, then in such cases, the defense of voluntary non-fit injuria will not be available to the defendant. Here, I will discuss about very famous case for the rescue cases is Heinz versus Harwood. In this Heinz versus Harwood case, the defendant's servant left two unattended horses in a public street. The boy threw a stone on the horses, due to which they bolted and created danger for a woman and other people on the road. So, a constable came forward to protect them and suffered injuries while doing so. This being a rescue case, so the defense of voluntary non-fit injuria was not available and the defendants were held liable. However, if a person voluntarily attempts to stop a horse which creates no danger, then he will not get any remedy. Now, I will discuss about Unfair Contract Terms Act 1977. The Unfair Contract Terms Act 1977 limits the right of a person to exclude his liability resulting from his negligence in a contract. Negligence liability, subsection 1 puts an absolute ban on a person's right to exclude his liability for death or personal injury resulting from the negligence by making a contract or giving a notice. Subsection 2 is for the cases in which the damage caused to the plaintiff is other than personal injury or death. In such cases, the liability can only be avoided if a contract term or notice satisfies the reasonability criteria. Subsection 3 says that a mere notice or agreement may be enough for providing that the defendant was not liable, but in addition to that, some proofs regarding the genuineness of the voluntary assumptions and plaintiff's consent should also be given. Now, I will discuss with the second defense, that is plaintiff the wrongdoer. There is a maxim ex turpi causa non oritur axio, which says that from an immoral cause no action arises. If the basis of the action by the plaintiff is an unlawful contract, then he will not succeed in his actions and he cannot recover damages. If a defendant asserts that the claimant himself is the wrongdoer and is not entitled to the damages, then it does not mean that the court will declare him free from the liability, but he will not be liable under this head. In the case of Bird versus Holbrook, the plaintiff was entitled to recover damages suffered by him due to the spring guns set by him in his garden without any notice for the same. In Pitts versus Hunt, there was a rider who was 18 years of age. He encouraged his friend, who was 16 years old, to drive fast under drunken condition, but their motorcycle met with an accident. The driver died on the spot. The pillion rider suffered serious injuries and filed, filed a suit for claiming compensation from the relatives of the deceased person. The plea was rejected as he himself was the wrongdoer in this case. Now, I will discuss with the third defense, that is the inevitable accident. Accident means an unexpected injury, and if the same accident could not have been stopped or avoided in spite of taking all due care and precautions on the part of the defendant, then we call it an inevitable accident. It serves as a good defense as the defendant could show that the injury could not be stopped even after taking all the precautions and there was no intent to harm the plaintiff. Now let's discuss with the famous case of the topic inevitable accident. The name of the case is Stanley versus Powell. In this Stanley versus Powell case, the defendant and the plaintiff went to a pheasant shooting. The defendant fired at a pheasant, but the bullet, after getting reflected by an oak tree, hit the plaintiff and he suffered serious injuries. The incident was considered an inevitable accident and the defendant was not liable in this case. Now I will discuss the second case, for the same defense inevitable accident is the case Assam State Corporation Federation Limited versus Srimati Anubha Sena. In this case, the premises which belonged to the plaintiff were let out to the defendant. The tenant, that is the defendant, requested the landlord to repair the electric wirings of the portion which were defective, but the landlord did not take it seriously and failed to do so. Due to a short circuit, an accidental fire spread in the house. No negligence was there from the tenant's side. In an action by the landlord to claim compensation for the same, it was held that this was the case of an inevitable accident and the tenant is not liable. Now I will discuss with the fourth defense, that is act of God. Act of God serves as a good defense under the law of torts. It is also recognized as a valid defense in the rule of strict liability in the case of Rylands versus Fletcher. The defense of act of God, an inevitable accident, might look the same, but they are different. Act of God is a kind of inevitable accident in which the natural forces play their role and causes damage. For example, heavy rainfall, storms, tides, etc. Essentials required for this defense are natural forces working should be there, and second essential is there must be an extraordinary occurrence. There must be an extraordinary occurrence and not the one which could be anticipated and guarded against reasonably. For working of natural forces, to explain working of natural forces, I will explain with the help of a case law, Ramalinga Nadar versus Narayan Reddyar. In this case, the unruly mob robbed all the goods transported in the defendant's lorry. It cannot be considered to be an act of God, and the defendant, as a common courier, it will be compensated for all the loss suffered by him. One more case law is there to explain the working of natural forces, that is Nichols versus Marsland. In this Nichols versus Marsland case, the defendant created an artificial lake on his land by collecting water from natural streams. Once there was an extraordinary rainfall, heaviest in human memory. The embankments of the lake got destroyed and washed away all the four bridges belonging to the plaintiff. The court held that the defendants were not liable as the same was due to the act of God. Now I will explain about the occurrence must be extraordinary. Some extraordinary occurrence of natural forces is required to plead the defense under the law of torts. In Kalulal versus Hemchand, the wall of a building collapsed due to normal rainfall of about 2.66 inches. The incident resulted in the death of the respondent's children. The court held that the defense of act of God cannot be pleaded by the appellants in the case, as that much rainfall was normal and something extraordinary is required to plead this defense. The appellant was held liable. Now I will discuss with the fifth general defense, that is private defense. The law has given permission to protect one's life and property, and for what that it has allowed the use of reasonable force to protect himself and his property. The use of force is justified only for the purpose of self defense. There should be an imminent threat to a person's life or property. For example, A would not be justified in using force against B just because he believes that someday he will be attacked by B. The force used must be reasonable and to repel an imminent danger. For example, if A tried to commit a robbery in the house of B and B just drew his sword and chopped his head, then this act of A would not be justified and the defense of private defense cannot be pleaded. In Bird versus Holbrook, the defendant fixed up spring guns in his garden without displaying any notice regarding the same, and the plaintiff, who was a trespasser, suffered injuries due to its automatic discharge. The court held that this act of the defendant is not justified and the plaintiff is entitled to get compensation for the injuries suffered by him. Now I will discuss the sixth general defense, that is mistake. The mistake is of two types: mistake of law, mistake of fact. In both conditions, no defense is available to the defendant. When a defendant acts under a mistake, belief in some situations, then he may use the defense of mistake to avoid his liability under the law of torts. In Morrison versus Ritchie and Cooperatives, the defendant by mistake published a statement that the plaintiff had given birth to two twins in good faith. The reality of the matter was that the plaintiff got married just 2 months before. The defendant was held liable for the offense of defamation, and the element of good faith is immaterial in such cases. In Consolidated Company versus Curtis, an auctioneer auctioned some goods of his customer, believing that the goods belonged to him. But then the true owner filed a suit against the auctioneer for the tort of conversion. The court held auctioneer liable and mentioned that the mistake of fact is not a defense that can be pleaded here. Now I will discuss with the seventh general defense, that is necessity. If an act is done to prevent greater harm, even though the act was done intentionally, is not actionable and serves as a good defense. It should be distinguished with private defense and an inevitable accident. The following points should be considered. In necessity, the infliction of harm is upon an innocent, whereas in case of private defense, the plaintiff is himself a wrongdoer. In necessity, the harm is done intentionally, whereas in case of an inevitable accident, The harm is caused in spite of making all the efforts to avoid it. For example, performing an operation of an unconscious patient just to save his life is justified. In Lake versus Gladstone, it was held that the forcible feeding of a person who was hunger striking in a prison served as a good defense for the tort of battery. In Cope versus Saab also, the defendant entered the plaintiff's premises to stop the spread of fire in the adjoining land where the defendant's master had the shooting rights. Since the defendant's act was prevent greater harm, so he was held not liable for trespass. Now I will discuss with the last and eighth general defense, that is the statutory authority. In statutory authority, if an act is authorized by any act or statute, then it is not actionable even if it would constitute a tort otherwise. It is a complete defense, and the injured party has no remedy except for claiming compensation as may have been provided by the statute. Immunity under statutory authority is not given only for the harm which is obvious, but also for the harm which is incidental. In Hammersmith Rail and Cooperative versus Brand, the value of the property of the plaintiff depreciated due to the loud noise and vibrations produced from the running trains on the railway line, which was constructed under a statutory provision. The court held that nothing can be claimed for the damage suffered as it was done as per the statutory provisions, and if something is authorized by any statute or legislature, then it serves as a complete defense. The defendant was held not liable in the case. The statutory authority has two types of authority, that is absolute and conditional authority. The authority given by a statute can be of two types, that is absolute and conditional. In the case of absolute authority, there is no liability if the nuisance or some other harm necessity results. But when the authority is conditional, it means that same is possible without nuisance or any other harm. So all the 8 general defenses have been discussed in today's session. I hope you all will like it. Thank you so much, everyone.